Xolani Guti, Ayamkela Zonke, Andy Swaputani. Today's date of worship is the 7th of October. This is appearances as 4 cases on the road today for
I confirm that the hearing on behalf of Chief number 1.
Confirm appearance on behalf of number 2, Your Worship.
Yes.
I confirm that I appear on behalf of number 2.
Thank you. Before I proceed, could you just confirm with Mr. Guti?
Yes. Yes.
Thank you, Bishop. Thank you, Bishop. Your Worship, I proceed
Yes.
in this application. Your Worship, the issues certainly that I need to focus on is just the issue of the regarding this requirement, whether there's a likelihood that the applicant will or can probably evade trial. I think that is the most pertinent issue, in more particularly in regard to Mr. Guti, in so far as it relates to his arrest. Otherwise, the rest of the other issues or requirements, they have not been evidence before this court where they have been challenged. But this issue becomes quite pertinent in this case.
The likelihood
Exactly.
to evade trial.
The nature of his arrest raises this. So I will only deal with that issue in respect of my argument. And the second issue that I'm going to deal with the question of the prospects of success. In other words, whether the state has got a good case.
Or in other words, you are
case
going to,
mistakes.
so in other words, you are going to deal with whether the state has got a strong case against him or not.
Exactly.
Okay.
These are the two issues that I'm going to deal with. And then the rest will be just other issues to add.
You are not going to deal with whether he has discharged the honors.
Yes.
There are exceptional circumstances which
Yes.
the interest of justice. You are not going to deal because we did not mention that.
Yes, no, what I'm saying, when I say I'm going to deal with it, whether they got a good case, then that is exactly what I meant, that will be, I will be suggesting, or be submitting with this court that he has proved that exceptional circumstances exist.
Thank you.
On that ground.
All right.
Yes, on that ground.
I understand.
Thank you. Your Worship, sometimes I just need to go to briefly to some case law. Before now, I interpret a factual situation regarding this issue. The last issue I dealt with regarding the question of exceptional circumstances. Yes, it is common cause and known very well that this concept has not been defined in our law, but subsequently case law emerged which actually gave some meaning, some meat into what is constituted by this concept. The court just stay for a moment, which is
Yes.
I refer in this regard to Detroit et al. Criminal procedure.
You are referring to the book by
By
Detroit.
Detroit et
Is
al.
that now the commentary?
To comment. Yes. That is, I'm referring to a particular section, but the commentary is at page 9, stroke 9. When you refer to the case of Dlamini, the well-known decision of Dlamini,
The Constitutional Court.
Constitutional Court decision, where the Constitutional Court held that although the inclusion of the requirement exceptional circumstances limits the right enshrined in section 35(1) of the Constitution, it is a limitation which is reasonable. Fine. So, because in this case, there was an attack on the constitutional validity of that section. Hence the court said that, likewise, I do not agree that because of the wide variety of ordinary circumstances enumerated, it is virtually impossible to imagine what would constitute exceptional circumstances. So because in that case, the council argued that if you think about exceptional circumstances, you can never imagine that. That's why now the subsequent decisions have alluded to the interpretation that the normal circumstances that are enumerated in the bail legislation, a court has got the discretion when it finds that they have not been shown to be non-existent, to find that they are exceptional circumstances. So in other words, without reverting to the question of the state case, that the normal circumstances that are enumerated in section 6 of the bail application. Now, I am not going to...
What should I regard as being exceptional in applicant's number 1's circumstances?
Yes.
What is it that I should regard as being exceptional in his circumstances?
In applicant number 1. You see, hence I am going on to say these issues, the problem with bail there, they have to be taken in conglomeration, not one aspect. Yeah, and then once you take all of them now, hence I want to argue the issue of the state case in respect of accused number 1. If we now, accused number 1 has not given an explanation or a version for this one, then the only evidence before this court purported to be a version was that of the idol.
Yes.
Yes. Then I submit that I asked her a question. Did you warn accused number 1 before taking the statement? And then she said to me, no. She said, no, she could have been warned, perhaps. When,
Someone else.
yes, when she was making a pointing out. That is later on.
Yes.
So that is in flagrant, obviously, violation of constitutional right of a suspect to simply interview and not take anyone's statement and say, no, maybe it was one later. Without ado. More particularly, taking incriminating evidence, as he has testified here, and say before a court of law, no, I never warned him. He must have been warned by somebody else. Literally. There is no court of law must submit that can ever admit such an evidence against the appellant. There's a line of decisions that says that at every aspect of an interview of a suspect, he must be warned.
And that's for the trial court, not...
Exactly. Now,
We are at a pre-trial stage now.
that is why now the issue of the probability of acquittal becomes relevant in this court, where it's not like we are. It's a situation of peeping and see what would be the problem, what probably would happen, not ready to go into trial.
Yes, I do appreciate the fact that you are alive to the fact that we are at the pre-trial stage.
Yes,
We are not trying these applicants.
that is all.
Yes, we are not.
Yes, that is that. No, my take is this. This is not a mini trial. This is a bail application.
Yes.
Being it a bail application, an applicant in a bail application is allowed to show that, look, the state is charging me, but this case is either non-existent or it is serious to some serious harm.
Yes.
We can only know that by peeping, looking through the glass and seeing what would probably happen there.
Yes.
So that's basically what I'm doing. I'm not embarking on a trial. I think what to get all the way. And then, that is with regard to that statement. And then, with regard to the pointing out,
Yes.
the pointing out, she says that somebody made the pointing out. But we do not know whether this pointing out was incriminating or was exculpatory. Somebody can go and point and say, this is the scene where the caretaker said he killed Kungawo. This witness did not say anything about
Just
what
before we can go to the pointing out, Council.
Yes.
According to the investigating officer, did number one make a confession?
No.
So number one did not make a confession?
No.
No confession?
Exactly.
Yes, but pointing out.
It's just a pointing out.
Did you see that pointing out, the circumstances of the man upon which it was taken?
No.
Did not?
It was never, no. Since we are not allowed, this defense will not be allowed to inspect the docket at the stage.
I know, but the pointing out, in as far as I'm concerned,
Yes.
let me make just a list of things that you are supposed to get during the application.
That's-
Things that you are supposed to apply for and get during bail application, before bail application just starts. You can make an application to be furnished with a warning statement of your client prior to bail proceedings.
Right.
That's number one. You can make an application to be provided with a confession if there's any made by your client. You can make an application to be furnished with a copy of a pointing out if there's any that has been made by your client. You can make an application to be furnished with any statement that has been made by your client wherein he signed the statement. If you've got the Criminal Procedure Act with you, I know you do.
Yes.
Take it, I want to show you. I don't have it with me, but I know it by heart.
16? No.
Section, you've got the CPA?
Yes, I do.
Section 3, take that one. Take the smaller one. Go to section 335. 335. 335. 335.
All right.
Are you there? 335, yes.
Yes.
I know it. It's supposed to be there. Now,
Okay.
do you see it?
Yes, I see that.
What does it say? For the record.
The 325A
Yes.
and B.
Yes.
It said prohibition of publication of identity of persons towards or in connection with whom certain offences have been committed. And then B,
Can I have the
medical examination of minors.
Okay. We are not reading the same section. This is the provision that I'm referring to. Section 335, not 335A or B.
Yes.
I will give it back to you. Let me just read it for the record. So that we are on par with this.
Yes.
335 as I've indicated earlier. Section 335 reads as follows. Person who makes a statement is entitled to a copy thereof. Whenever a person has in relation to any matter made to a peace officer, a statement in writing or a statement which was reduced to writing, and criminal proceedings are thereafter instituted against such a person in connection with that matter.
Understood.
The person in possession of such a statement shall furnish the person who made the statement at the request with a copy of such a statement. Closed.
Fine.
Now, I'm saying, counsel,
Fine.
before a bail application can start, okay? Before a bail application can start, the applicant, through his legal representative,
Yes.
may apply for a warning statement. He must get it. He must apply for a confession if there's any. He's entitled to it. He must apply for a pointing out if there's any. He's entitled to it. All the statements wherein the applicant is the author thereof,
Yes.
in terms of section 335, he is entitled to those statements, regardless of whether it's still bail application or not. So what I'm trying to say, counsel, is that it would have been proper, and I want you to be with me, it would have been proper, or rather, for lack of a better word, it would have been prudent for applicant number one, upon realizing that there is this purported pointing out, okay? It would have been prudent for him to make an application for that pointing out, so that when the time comes for the investigating officer to talk about what is contained in the pointing out, the circumstances upon which it was done, you have it before you. You can see if there was any compliance with section 35 of the Constitution, where the rights explained, did your client sign, where the issue was the issue of legal representation mentioned, and all such things, right? Now, that has not been done. And I'm not saying you must not attack the evidence of the investigation. Of course, you must attack it. But what I'm trying to say is that it would have been better if the investigating officer was invited to say, okay, fine, you did this pointing out, or the pointing out was done, but A and B and C were not complied with. These are the rights of my clients that were infringed. I'm not sure if you're with me.
I understand what.
Yes. So, I am not saying don't attack the IO. You must attack the IO because you have to attack the IO. But what I'm trying to say, I would have been in a better position as a presiding officer if this pointing out was requested by the applicant. That is number one. And upon being furnished with it, the investigating officer was then cross-examined based on the document. Because if we are talking about the pointing out, we're talking about something which is written in black and white. So I would have been in a better position now to see if there was any compliance with section 35 of the Constitution when that pointing out was taken. I'm not sure if you're with me. Now
I'm waiting for you to finish.
Yes. Now I'm at sea in as far as that is concerned. I'm at sea because it has never been put to the investigating officer, in my view, or according to the record, that this purported pointing out that was taken from applicant number one does not comply with this and that. He had indicated that he wants a legal representative, but you continued with the pointing out despite that. So, and so on, and there are so many things that can be challenged in a pointing out, as you know. There are so many things that have been challenged, that can be challenged in a pointing out. But up to this stage, that has not happened. All that we have heard is that he has made a pointing out, he did not make a confession. So I was just bringing this to your attention, counsel,
I understand, Your Worship.
Yes.
I understand.
So we are now agreeable that during bail application, you can get all the things I've referred to, not so.
Can Your Worship allow me?
Yes, I will allow. Yes, I will allow.
I think we are in serious disagreement
Mm.
about these issues.
Mm-hmm.
In a bail application, I am not in a trial here. I'm not in a mini trial.
Yeah.
I am not going to leave evidence where Your Worship would have to determine the admissibility of pointing out. The only thing I can do in a bail application, I can go to any extent that is a level.
No,
I will
no.
not jeopardize the
So-
interest of accused number one.
So,
Yes.
it's not the admissibility.
Yes,
It's
yes.
not- No, I don't think we are together on this. I can never say, let us go to the admissibility of a document during a bail application, because that is for the trial court to do. What I'm saying, counsel, is this, and I want you to listen very carefully, because if we are not moving together, then there's going to be a problem. What I'm saying, counsel, with respect is this. Had applicant number one been privy to the document, right? Had he been privy to this pointing out during this bail application, which in my view, he was entitled to. Had he been privy, it would have been better then that during cross-examination, it is put to the IO that the pointing out that you did does not comply with Section 35. That's not admissibility. It's something that you are going to challenge in the subsequent trial, Mr. Chairman. Okay? Tell the IO during cross-examination that you've conducted the pointing out, but we are going to challenge it in the main trial because it doesn't comply with A, B, and C. Not at this stage. So I would have expected that from you.
With respect, Your Worship, on that point, there is nothing that I've done which is unprocedural. That I can cross-examine
No,
this. You know the problem.
I'm not saying you've done anything unprocedural here.
You see the problem. here?
Cousin, look, cousin, look.
Yeah.
Look, I'm sorry.
I
Cousin,
understand.
cousin, you did not do anything untoward, okay? What I am saying to you is that it would have put me in a better position if the investigating officer was invited to comment on the pointing out document. I'm not saying that it's your fault, but I am saying it would have put
All right.
me in a better position
Thank you.
if she was confronted with the document of the pointing out. Okay?
Fine.
Yes.
My argument in that regard, you see,
Mm.
this witness, the state has arrested the accused.
Yeah.
They opposed the bail application
Mm.
and they testified.
Yes.
So it is expected in this kind of an inquiry
Yes.
that she must come with sufficient evidence to oppose the release of the accused.
Precisely.
And then if she says, and she said, there is a pointing out, but there is a certain police official who made that pointing out, it's not me. She doesn't go too further to any detail. And this court, as it stays here, it cannot say that pointing out was incriminating.
No, it's not.
That's what I'm saying. It does not know, because the state actually has failed to show, to lead that evidence and say that in that pointing out, was it accompanied by incriminating notes? And that was never done. So now, if it is not done, then this court stays not knowing to what extent the strength of the state's case is. On that regard, those are my submissions in that regard. Then we move to the issue as I've submitted that no confessing before this court, incriminating, fine.
Yes.
And he accused number one, has gave evidence before this court,
Yes.
which was not seriously disputed that he was assaulted. He's got evidence, medical evidence, that I was assaulted. You see, so It's my submission that, as I have said, that issue regarding the pointing out and the fact that he never made any confession, it can never be said that the state's case is strong. Cannot be. And if that is the case, then he has established exceptional circumstances. And I further submit that his personal circumstances as a teacher, who actually he would be able to get a temporary employment, as a SGB post.
Is he still employed by that school?
You see, with regard to this, I've discussed this aspect with my colleague, that the principal of Mr. Koiti came and saw me, and he also saw my colleague with a letter. That letter was from the Department of Education in Sweden, where they said that he should be suspended. He is suspended. And then the principal gave the letter to me. And I showed the principal that no, this letter is wrong. Because they were under the impression in that letter that he has killed a scholar at his school. In fact, they stated
In the letter.
yes, in that letter that he killed the school at Alice Primary. Then I pointed it to the principal that, no man, if this was only the mistake, without, there were consequences flowing from that, even SACEs, South African schools, that organization. So I said, no, at least they should understand, it's not a scholar from primary. Then the principal mounted those, he said, they must send it back that suspension letter, to be sure.
Yes.
Then I told my colleague, she never brought that suspension letter back. The principal. I tried to phone him this morning to find out, but I didn't get him. That's a true letter she brought it to my...
Okay. So now, in light of those prevailing circumstances, there had not been another
suspension letter.
when that one was returned.
Written there to be sure. So, Your Worship, I have also...
With that being absent, are you still of the view that if he gets bail, he will go back and work at the very same school?
Not at that school. Not at that school. He can't, Your Worship.
He can't work at the very same school?
Not at that school. As he said, he can only ask for employment as maybe SGP post, wherever he will stay, or a temporary teacher. Not at that school.
Or he's not prepared to go back to that school?
Not prepared to go back to that school.
I see.
Another aspect, Your Worship, after this investigative officer testified, that I asked him, myself, the fact that you say Mr. Kochi was running away, because Mr. Kochi said that no, he even phoned Mr. Tukada, who is the principal, deputy principal, to go and report. But he said, well, if there was such evidence in the occurrence school, then if there was such a thing, it would be in the occurrence. Then I said to, okay, fine. Then I went to the occurrence school, and then I showed my colleague a copy of the occurrence book at the police station, after he testified.
Yes.
Then I got a copy of the occurrence book, which confirms that there was a report on that day. But and immediately, about 2 hours after the report was made, then the police went to Dotwe to arrest him. I got a copy of this document. I saw last week, I showed my colleague immediately when I got this document. Yes. But I handed it in. Is it possible? Or is it sufficient?
Madam, have you had sight of what counsel is talking about?
I did have sight of what he's talking about, Your Worship, and we did discuss it last week. But I told him that occurrence book does not say the whereabouts of the applicant. It just says the applicant called me and this is what he said to me, that he has killed Kungawo. There's no specification of the whereabouts of the accused person. That's what I've discussed with him last week and we agreed. But I did tell him that he can submit it last week if he wanted to. I was not going to object. But
now?
You see?
My view is, my question is, have you had sight of that? And do you have any objections that you handed in?
if it's the same document, Your Worship, I don't have an objection.
Yes. Your Worship, I believe that, what happened last week. She really said, told me, as she says, that no, this document doesn't say where Mr. Kungawo. And then I thought immediately maybe I got a mistake. And then I went out. As I was going to Grimstad, I found somewhere, I read this document. I found no, my colleague is mistaken. She said that, he said that it was a document.
Can you read that
All right.
for the record?
There is a Mr. Elliot M. Takata,
Yes.
with a certain identification number, working at Fort Beaufort Primary, residing at Tukul Farm, and it came to CSC. It says 2 o'clock in 1400.
Yes.
To CSC, reporting that he managed to conduct Mr. Kolani Koji, a teacher at primary school, and he mentioned his cell phone number,
Yes.
who was involved in the killing of Kungawo, Marku, a 15-year-old. He was. He also then explained that to me that Mzwandile Janji, Andiswa Janji Isi, his wife and his girlfriend, they killed Kungawo. He further told me that according to the information he received from Mr. Kolani, that Mzwandile drove the car over Kungawo and further he further explained that Kolani told him that he is a daughter and Mr. Mzwandile had killed himself. So it's on my realization that there was a mention of daughter in this. But later on, so I couldn't come back to my colleague.
So you want to hand in this document?
I want to hand in this document.
If I may ask, how is it going to assist number one?
Because of the fact that, number one, it said he never at any stage was a doctor. So this is to show that there was such a report made to Mr. Takada to the police station on that aspect. Just on that aspect. But the rest of the other
Things that has been
aspects
said,
in this, I am not dealing with them. Because I'm not dealing with them.
but they are there.
Yes, but I'm not dealing with those aspects. If the court can consider them,
No,
I'm
it's
not
fine.
going to present argument.
No, it's fine. If there's no objection, I can have those.
This court cases.
If there's no objection, it's okay.
Thank you.
Okay, we proceed.
Thank you. Worship, it is my submission that the fact that the law provides that the conditions of bail can be quite very stringent is to ameliorate this possibility of unnecessarily incarcerated in applicant. So I move now to say that this court should consider the situation also that Mr. Kowati can be released on very strict conditions, or strict conditions, such as, for instance, reporting on many occasions to a police station where, because he indicated that he got an alternative address in Kingston.
So in a nutshell, you are saying he can be released on stringent bail conditions.
That is so. And I submit further that bail conditions also can be coupled with an amount of money, a substantial amount of money.
But based on affordability, of course.
Exactly, you will see.
There is this thing that was bothers me to an extent, Mr. Stemba.
Thank you, the chief.
And this is the thing that bothers me. And I want you to address me on this issue. We have had evidence in this bill, in this bill proceedings that applicant number 1 is in a love relationship with applicant number 2. That is the evidence before me. Now, there is evidence before me that the deceased was in a love relationship with applicant number 1.
Oh, yes.
not
It says was in a lot of things. No.
What I'm saying
The
is,
deceased.
the deceased in this case
In a love
was
relationship.
in a relationship with applicant number 1.
Right.
Not so. That is the evidence that is before me.
I see. Okay.
Unless they have been
That is so
attending
wrong.
some other proceedings somewhere else.
No, I want to just mistake the caretaker, you know.
Yes.
Yeah.
No,
it is so. It is
Don't
so.
go to the caretaker and applicant number
Yes,
3.
because I was arguing with the caretaker. I was arguing. Okay, fine. It is true. It is
Now,
true.
just wait for my question.
Yeah, that is so.
Now, so if that is true,
Yeah.
I'm glad that we are now together. Now, when applicant number 2 testified and gave evidence, viva voce, she said, number 2 now, and she was still represented by you before you withdrew as
Yes.
as counsel of the court. She said, we had gone to the deceased place upon being requested by applicant number 1.
Yes.
Now, I want you to listen to this before you can proceed with your further arguments. She said we had gone to the deceased place to fetch her upon being requested by applicant number 1 to do so. That she said under oath, it's on record. Now, here is my question. We have people who go or who went to fetch the deceased at her place of residence.
Yes.
Okay?
Common cause.
Yes, common cause. Thank you very much. Common cause. It's applicant number 2 and number 3 who went there. According to number 2, they were requested by number 1. Now, they got hold of the deceased. Right? They got hold of the deceased. Whether deceased was a willing participant or not, that is not the issue. And as far as now the kid is concerned, whether the deceased was a willing participant to go or not, that is not the issue. The issue is, now they all went inside the motor vehicle that was driven by applicant number 1. So in this motor vehicle, there was applicant number 1 who was in a relationship with applicant number 2,
Yes.
driving the motor vehicle. At the back, there is the deceased who was also applicant number 1's girlfriend, right? Bearing in mind, counsel, bearing in mind that there are allegations that the deceased had broken the windows
Yes.
of number 1's place. Whether he was renting there or not, I do not know. But there are these allegations that
Yes.
the windows there had been broken by the
And it
deceased.
is.
So, now in this motor vehicle, we have applicant number 1, who is the driver and the owner of the motor vehicle. He has got 2 girlfriends that are inside this motor vehicle.
Yes.
People are traveling, all of them are traveling from Alice to wherever they are going. Okay, they end up in Grahamstown. Now, my question, therefore, is to you is this, counsel. What could have been the motive if there was a, from number 1 to request number 2 to go and fetch the deceased at her place, get into the car, they travel wherever they went. What could have been the motive behind that? In light of the background I've just alluded to,
Yes.
what could have been the motive? It's specifically on number 1, to request number 2 and 3
Yes.
to go and fetch the deceased.
Yes.
Get into the car, go to wherever that they went.
Yes.
What could have been the motive?
Right. Firstly, I must say that it is for this court, it is absolutely not for this court to determine the motive of why people did so. This is not a trial. We
Yes.
must not miss the point that we are not here in a trial situation where you can interpret that motive
So
and find a choice.
so I should simply close my eyes when it comes to that.
You know, I choose number 1. He's never testified about going to Grahamstown with anybody.
I'm saying,
Yeah.
listen,
Yeah.
I'm saying that is evidence which is before me. That number 2 says he was requested by number 1 to go and fetch the deceased at her place. Why should I turn a blind eye to
Right.
that? Even if I'm not a trial court,
Right.
why should I turn a blind eye to that piece of evidence?
My submission is that you will see. If therefore, as I am hamstrung, if your worship wants to adjudicate this issue about the motive, I submit that, and I submit that I am not in a position to argue that the motive was, what was the motive? I can never know. I don't have instructions. I do not. I cannot know what was happening with them when they went into the car, because there's no evidence before this court that Kungawo was taken forcibly. So I don't know now what happened inside the car that might have led to other things happening.
All right.
And I don't, and it's not before this court.
All right. Now, while we are on the issue of the likelihood to the vain trial,
Yes.
this is the first issue that you alluded to when you argued.
Yes.
Now, on that one, counsel, there is evidence before me that there was a telephone conversation between applicant number 1 and the station commissioner earlier on that day. That, look, do you know the whereabouts of the deceased? Please, if you know, come to the station. There's that evidence before me, right?
Yes, that is so.
Yes. Now, here is my question, counsel. Applicant number 1 received a phone call from the station commissioner. The station commissioner was concerned about the whereabouts of the deceased, right?
Yes.
And requested to see him in the police station. Now, applicant was aware of that. Even before he went to King Williamstown, even before he went, he drove off
That is so.
towards Tatarem, Queenstown, wherever the case may be. Up until such time, counsel,
Yeah.
that a message was conveyed to him, and that is his evidence. Up until he was informed by the caretaker who had committed, before he committed suicide,
Yes.
that I am the one who killed the deceased.
Yes.
There is evidence before me. It's him saying that to me, that the caretaker informed me before he committed suicide that he is the one who killed the deceased, right? Now my question is, for someone who says I am not a flight risk, this question is important. And I repeat, for someone who says I want bail because I'm not a flight risk, the following question is important. Immediately after he learned or he became aware of what had happened to the deceased, what now prevented him now from calling the station commissioner who had called earlier on, asking about the whereabouts of the deceased? Now that he became aware, What prevented him now from phoning the station commissioner to say, station commissioner, earlier on, about your call earlier on, you asked me about the whereabouts of the deceased and you wanted me to come to your offices.
Yes.
The caretaker, before he committed suicide, he told me that it is him who killed the deceased.
Yes.
Are you with me, Council?
I understand.
For someone now who says, who argues strongly now before me that he is not a flight risk, in fact, we would not even be talking like this if immediately after he had learned that it was the caretaker who killed the deceased, if he had made arrangements with his attorney, because apparently he was talking to his attorney at the same time. If he had made arrangements with his attorney to approach all two of them, that is applicant number one and his attorney, they go to the station commissioner in Alice to say, this is the position. When you asked me earlier on about the deceased, I was not aware. But I have since become aware now because the caretaker, before he committed suicide, he informed me that he is the one who killed the deceased. It ends there. But now, he did not deem it fit to do so. Instead, he proceeds. I don't know whether, did he reach Dordrecht?
Yeah, I was in the area of Dordrecht.
He left Statter and Kimberley, Queenstown, up until he reached Dordrecht with that information. Now, with that information, so Council, for someone who says before me, Your Worship, release me on bail because I am not a flight risk. I am concerned about this question that I am asking because it became known to him what transpired to the deceased. He was informed, Council, by the caretaker before the caretaker committed suicide. It's him who says that I killed the deceased. From that very moment, applicant number one should have picked up the phone and said, Station Commissioner, someone has just told me something which is very big, that he killed the deceased. And I am coming to you as you wanted to see me. That's what a prudent person would have done under the circumstances. You may take instructions.
Yeah. Anyway, Worship, there is no argument that I can advance or accept things that have been said. So, but now, you think he gave evidence to the effect that he was running away from being from threats from the police. That's the evidence he gave. He was afraid of the police because they were speaking with him in such a rough way that he was. Yes.
Let me accept. I accept that.
Yeah.
Let me accept that he was afraid.
Yeah.
But now,
I'm coming to that point.
you come to that
I'm
point.
coming to where you're asking, but I'm tracing it from the beginning.
Please go to that.
Yeah, so there's no way I can just go directly, I must take it from. So he was afraid of the police at that moment. Because the police, he said that they were asking him about Kungawo, who he has no knowledge of killing. And he was of the apprehension that the police will assault him. So when he was when he heard the news about the caretaker, it could not be unexpected of a person not to immediately take that role under the situation that he was. It could not be. Because later on, the fact that he says, he phoned Mr. Tagada of the principal about this thing. I think that should be taken into his benefit. Otherwise, I will not give you that matter any thought.
I am not satisfied with this response, with respect, Council.
About why he never.
Look, this, Council, this is
No.
I understand where you're coming
Yes.
from, but to me, this response is not satisfactory. Why I'm saying this? A person who has conversed with the station commissioner
Yes.
earlier on that day regarding the whereabouts of the deceased, that person now becomes aware of what had transpired to the deceased.
Yes.
What is preventing, why would you be scared now to pick up the phone, call the station commissioner? You are somewhere in Dordrecht, the station commissioner is in Alice. Station commissioner, about you, what you asked me earlier on regarding the whereabouts of the deceased, I am now aware. It is the caretaker before he committed suicide. He told me that he killed the deceased. Why would someone be afraid of doing that? I mean, you are exonerating yourself by so doing, not so. You are exonerating yourself. Why did he not choose to exonerate himself?
I understand your concern
Why?
in that regard, at that point. But we have to also look at this aspect that Mr. Koji, in his evidence, he said that at the time that he realized that caretaker is killing himself, it was at the time that he was communicating with his lawyer and Scorpio. See, so I am not going to assume on his behalf, because he says that he was in a hysteric mood at that time, phoning lawyers and phoning Scorpio, and then caretaker is killing himself. That's why I can take it from the evidence that is before this court. So my submission is that.
Mr. Koji, do you want me to take instructions from you? Yes, yes.
Yes. Your Worship, there was evidence before this court.
Yes.
When you recall when he said that he was under emotional blackmail because his caretaker was said that you never said share this to anybody because of the children, the wife, So the possibility, because now we want to grope into the dark now, to grope and find. So there existed possibility in this emotional situation that he was. And this, as he testified that it was emotional blackmail. So at that moment, he could immediately think of doing, as you reasonably say, what you have done. I submit.
Who was going to do something to him had he disclosed that to the station commission? Who was going to do anything to him had he disclosed that to the station commission?
No, he's saying that the caretaker was asking him. So
not to disclose.
Yes, not to disclose. So
that he had killed the deceased.
Exactly, that is the evidence that he gave.
But the caretaker now is gone. He has committed suicide. Is gone.
Yes.
What prevented him now from telling the station commission?
Yes, hence I submit that now, if you look, I'm not being able to fumble into darkness about the situation where somebody says that I'm in a stressful situation that I was afraid and I could not do that thing. I cannot apply an armchair judgment situation. Those are my submission in that regard. Those are my submission. Thank you.
Is that all? No, okay. Don't.
Yes,
Mr. Koji, if you want to take instructions from, if you want your counsel to take instructions from you, give him proper instructions. Don't expect the court to, from now, time and again, say, counsel, take instructions, counsel, take instructions. No. You understand?
Nomzamukotike ubana ke ufuna uthetha negqwetha lakho ivezo lonto kakuhle kuba ungalindeli inkundla uba imane ithetha isithi kwigqwetha lakho ubana unomzamukoti ufuna uthetha naye.
There is nothing wrong when you are raising your hand. I mean, it's your right to do so.
Akho nto ingalunganga ke uphakamiseni isandla sakho xa kukho into ufuna ukuyiveza kwigqwetha lakho.
But now, as we proceed now, as I'm engaged in council, you continue now raising your hand, and I'm saying now council. So council now is taking instructions in piecemeals.
Uke umane uphakamisa isandla umane ngiqhawula phakathi ngisathetha negqwetha lakho. Uke ilento uyithetha izizijuma ezifutshane.
So council, I will allow you to take instructions. I will allow you.
Yes. Yeah, cheers. Thank you, Richard. What should be concerned is, I think I submitted this that immediately after that, he phoned his deputy principal, Mr. Tabaka. Yeah.
Now that one is on record, I'm aware.
Yes, it's on record.
It's on record.
Some explaining. Yeah.
But just before you can take your seat, council, I want to invite you on this. You see, the evidence that was brought to this court by the investigating officer, from the beginning up until the end, the manner in which the deceased was taken
Yes.
at her place, traveling to Grahamstown, everything that happened to the deceased was there. According to the investigating officer, she said she got that from applicant number 1. Before you can take your seat, I want you to address me this, because everything that the investigating officer, it was said, in as far as the merits of the case are concerned, everything that she said before this court, how the deceased were taken from her place, how she got killed, and after the killing, people went to consume intoxicating beverages, went back to check if there were no leftovers of the specimens. They found some specimens, put them in the car, traveling with them, and all such things. This is the evidence that cropped up during the evidence of the investigating officer. What have you got to say to this? More so that you are saying you got that from applicant number 1. What have you got?
Which is in light of the fact that this evidence is so obviously incriminating. And accused number 1 has indicated so clearly before this court that he did not kill him, he's got no knowledge. And also in respect of this document that I submitted before this court, that he said that he does not implicate himself in killing Kungawo. Those are my submissions.
What about the petition that has been submitted?
He will not be staying in Alice. He says he's going to be staying in, well, he gave evidence that he's going to place a home. He didn't specify in Kungawo, where you pay. And if possible, you can, as it is the case, then that condition of bail can be amended if necessary.
All right. Okay. Thank you, sir. Thank you very much.
Thank you. Thank you.
To the members of the people seated at the gala, it has been brought to my attention that there is a cell phone that is on as well as sitting here. And if that is the case, then it's a problem.
Ngokuqala ke ndiyaziswa ukubana ke ikhona ifowuni evuliweyo apho kuni apho nje bendihlela apho nje kwaye ke iyasiphazamisa apho isibangela ingxaki ngoku.
I had said this, I do not know for how many times,
Ithethile le nto andiyazi uba amatyeli amangaphi.
that if a cell phone is on, it doesn't matter if it's on silent. If it's not on flight mode, there's a cell phone that is on in court, as we are proceeding here. There's going to be a huge problem at the end of this case.
Ithethile kaloku into yokuba ifowuni nokuba nayo ungayifaka ku-silent uba ingakhali kodwa ke iyasiphazamisa ukuba nje ilayitile qha iyayiphazamisa.
Because at the end of these proceedings, if one of the applicants is not satisfied with the ruling of this court, he may take me to the High Court on appeal.
Kuba kaloku ekugqibeleni kweli tyala ke ukubana omnye omangalelwa akanelisekanga zizigqibo zale nkundla uyawuthi ke abhene aye kwinkundla ephakamileyo.
The judges in the High Court are going to make a ruling based on what was happening here. They will listen to what was happening here. If there's a cell phone, they will not be able to do so.
Kuba kaloku ijaji phaya eHigh Court zawuthi xa zithatha isigqibo zijonge yonke into eshicilelwe apha ngexesha kuqhutywa eli tyala kwaye ke ngokubana kukho ifowuni ezimane ziphazamisa abazukwazi ukuthatha eso sigqibo.
And let me tell you for your information, if the record cannot be transcribed for the judges to listen to and read, accused will be released in the High Court.
Kwaye ke mandinixelele le nto ndizama ukunibonisa ukubana ke ukushicilelwa kwenziwa lapha enkundleni xana phayana ijaji e-High Court zama ukufunda ezanto zishicilelweyo phayana ube kukho ifowuni ibiphazamisile umntu lo bemangalelwa uyawuthi afunyaniswe ingenatyala ngenxa.
So I don't understand why must I beg members of the public who are adults who come to court and I tell them the same thing every day. I do not know why I should be begging adult people.
Andiqondi naleyo ubana kutheni le nto kuzawufuna ndicenge abantu abadala abasuke ngapha ezindlini zabo baza enkundleni bezomamela amatyala kodwa bazawuphinda bangacimi iifowuni zabo.
This is really, really frustrating, for lack of a better word. I am very frustrated by the conduct of the members of the public in Alice.
Loo nto ayindiphathi kahle ke bantu bokuhlala balapha eAlice ngeyobana mane ndikhalelwa ziifowuni apha enkundleni.
Right. Because it doesn't help to mislead me to say, I've switched off my cell phone. Miss Ula is the one who is listening. She can hear exactly that there is a cell phone. I can't hear. It's her who informs me. So please, with all due respect, I am humbling myself before you. Please, if you are in court and you are expecting an urgent call, rather leave. All right. Mr. Yes, you may address me.
Your Worship, if they may please be seated.
No, it's fine, they can be seated.
So, yeah.
Just before you can start with your arguments, I'm going to allow the interpreter to just try and summarize the argument by Advocate Stem. Just a summary, Mr. Mrs.
Okay. Uthe ke igqwetha likaMmangalelwa wokuqala qala lithetha lithe lizawugxila kwiinto ezimbini nje kuphela kuqala xana lifaka ingxoxo-mpikiswano apha kweli tyala. Ke uzawuqala aveze into yokubana ke ummangalelwa lo wokuqala ingathi kanti ingaba ngumntu onothi aqaleke ityala kwaye loo nto leyo ibhekisele ngokuphetheleni ukubana indlela wayebanjwe ngayo. Into yesibini ayiphakamisayo ungaba umbuso unetyala eliqine kangakanani ngakummangalelwa lowo. Kwaye ke uthi ubana loo nto leyo ingathi iveze ke neemeko uzawuthi xa ichaphazela yona achaphazele neemeko ezikhethekileyo abonakalisa ubana ummangalelwa lona unazo iimeko ezikhethekileyo ezimthetheleyo uba makakhutshwe ngaphandle ngeveki. Uthi le nto iyavela into yobana ke yenziwa ngabantu abaninzi kwaye wathi wacaphula phaa kwincwadi kaDutoit page 9 apho isigqibo senkundla ye-Constitutional Court waphinda wathi ubana ke apha kwicaphula no-section 35 phaa kwi-Constitution esithi ubana ke le nto ithintela amalungelo ingaba ilungelo elo lathinteleka elika-section 35 na. Kwaye ke ezi meko zikhethekileyo azibonakali kakuhle. Kodwa ke uthi ubana iimeko ezo funeka ke ziqwalaselwe zizonke. Xana imeko ijongwe nganye ayuthi zibonakale kakuhle kodwa zinothi ziqokelelwe zijongwe njengento enye zizonke iyawuthi kanti ziimeko zicace kakuhle ke ngoku. Kwaye ummangalelwa wokuqala akathanga wafaka ubungqina obubakhe apha enkundleni, ubungqina obumanyelwe yile nkundla bobo bukamphandi wetyala. Kwaye wayekhe wambuza uba umphandi wetyala ubana ingaba babemlumkisile na ummangalelwa wokuqala ngokubana ke kuthathwe iinkcukacha istatement ekutsho. Kodwa ke azange ummangalelwa lo wetyala wathi ubana hayi inoba ke wathi walunyukiswa ngabanye ababethathe istatement emva koko. loo nto ke u-advocate uyibona njengokophulwa kwelungelo lakhe ummangalelo wokuqala, kwaye inkundla mayingathathi obu bungqina bukamphandle wetyala njengobungqina obunokuthi bufakwe enkundleni, kwaye loo nto leyo ingabangela ukuba ummangalelwa lo abonwe njengomntu engenatyala. Waphakamisa into yokuba ummangalelwa kweli lixa akafiki usesisicelo sebheli esi akafikwa ukubana kuxoxwe ityala, ezinye izinto akazukuthi ke angene kuzo azithethe. Waye uphakamisile into yokuba umphandi wetyala waye wathi ukubana ngeli xesha kunye ummangalelwa wokuqala yokukhomba wayengakho yena njengomphandi wetyala, kwaye kwakuhambe amanye amapolisa. Kungezo zizathu ke ukubana ke le nto esithi mangathathwa ngumntu opheleleyo kusitsho u-advocate Stemba. Inkundla yaphakamisa ke ukubana ke iinkcukacha ezinothi zifakwe enkundleni phambi kokubana zinikwe ingqina okanye ummangalelwa phambi kokubana ke athi athethe apha phantsi kwezifungo, angathi anikwe i-warning statement nengxelo ye-confession yokubana ke ebeyokhomba, ne-statement nasiphi na i-statement esenziweyo saze sasayinwa lingqina okanye ngummangali. Wacaphula phaa inkundla phaa kwi-section 335 Criminal Procedure Act isithi umntu naphi na othi enze i-statement unelungelo ukubana ke athi anikwe ishicilelo lalo ukubana eso statement ebesenze kwipolisa okanye naphi na umntu womthetho. Kwaye lo mntu womthetho esingakuye eso statement ufuneka ke amnikile umntu lowo ebesenza i-statement ikopi yakhe. Kwaye inkundla yaveza into yokubana kubalulekile ukubana ke ummangalelwa wokuqala anikwe ezi nkcukacha ziphethelene netyala lakhe phambi kokubana kube kanti kwenziwa ibheyili, kwenzela uba igqwetha lakhe lizokwazi ukuqaphela izinto ingaba zenziwa ngendlela eyiyo na, phambi kokubana kube kanti ukuthi afake ubungqina apha enkundleni ngokuphethelene nebheyili yakhe. Igqwetha likammangalelwa wokuqala laphakamisa intoba indlela akwenziwa ngayo okukhomba azange ummangalelwa afake ubungqina obumbophelelayo etyaleni, kwaye ufake ubungqina ukubana yena waye wabethwa amapolisa, kodwa inkundla ayikayiqwalasa ayinikanga ngqwalasela loo nto leyo. Ephakamisa iimeko zikammangalelwa wokuqala ezikhethekileyo, uthe ukubana ke uyitishara kwaye ngathi aphinde aqeshwe njengomnye wabantu abaphangelayo njenge-school governing body, kwaye neleta leyo yokubana ummangalelwa ngoku uyagxothwa emsebenzini azange yayibhalwe izinto ngendlela erongo, kwaye ke wayisa kulumntu wayezisa kuyo ku-principal wayilungisa, kodwa ke azange iphinde ibuyiselwe kuwe, nombuso akaphinde umnike ngqelo ukubana kwenzeka ntoni emva koko. Kwaye ke ummangalelwa wokuqala kanqweneli uphinda ayophangela kulesa sikolo bephangela kuso, angathi ke azame umsebenzi kwenye indawo. Kwaye ecaphula advocate phaa kule ncwadi ye-occurrence book uyaveza ukuba umnumzana Elliot Mdakata ophangelayo e-Fort Beaufort Primary uhlala kuTukulu, ixesha phaa wango-2 waye wafaka ingxelo emapoliseni ukuba uye wakwazi ukuqhagamshelana nomnumzana uXolani Gotye wathi uyabandakanyeka ekubulaweni kaKungawo, ecacisa ukuba uMzwandile Dyanki Andiswa Dyanki's nguye uMzwandile uthe nguye owabulalayo uKungawo. Inkundla ke ayiphikisanga ubana ke kufakwe lolo nkcazo apha enkundleni, kwaye ugqwetha u-advocate Stemba waphakamisa into yokuba umthetho unayo imiqathango yebheli ukuba ingathi ibe ngqingqwa ukuze isuse ukubana ummangalelwa ngathi abaleke ityala. Umqathango wokuqala ungathi ubekwe ngokubana ke ummangalelwa amane eyokusayina emapoliseni rhoqo, kwaye ke nebheli ngathi iphakanyiswe ibe kwixabiso eliphezulu. Loo nto ingaza ukuba ngathi intele ukubana abaleke ityala lakhe. Inkundla yaphakamisa into yokuba ummangalelwa wokuqala wayethandana nommangalelwa wesibini, kwaye nomfi lo wayethandana nommangalelwa wokuqala. U-advocate wayivuma loo nto, kwaye inkundla yaphakamisa ukubana ngexesha ummangalelo wesibini elinikeza ubungqina uthe saya phayana kuloo mfi kuba sicelwe ngummangalelo wokuqala. Loo nto uyithethe apha enkundleni phantsi kwesifungo. Kwaye ke inkundla iphakamisa into yokuba bayenze bebobabini ummangalelo wokuqala, owesibini nommangalelo wesithathu, ubana bayathi bayothatha umfi. Inkundla yaphakamisa ukuba ummangalelwa umfi lo wayengumntu owayezihambela ngokuthanda kwakhe okanye waye wanyanzeliswa, loo nto leyo ayisiyonto esizawuthi sijonge ngoku. Eyona nto ibalulekileyo kwangoku yokuba baye bakhwela bonke bahamba ngemoto kammangalelo wokuqala. Kwaye ke kukhona nezityholo zokuba umfi lona waye wazophula iifestire zendlu kammangalelo wokuqala. Wabuza inkundla ukubana ingaba yintoni eyayibangela ukuba ummangalelwa wokuqala athume ummangalelo wesibini eyazi ukubana bona bayathandana. U-Advocate Stemba waphendula wathi ubana ngoku asikagxoxe ityala, kodwa ke inkundla yathi bubungqina bulapha phambi kwenkundla oko, kwaye inkundla ayifuni ukubana loo nto ingayiniki ingqwalasela. U-Advocate Stemba waphendula wathi ubana akakwazi ukubana athi afake ingxoxo ngaloo nto ukubana yayizithini injongo ngelaa xesha. Inkundla yathi ukuba ukubaleka ityala ikhona ubungqina apha enkundleni ukubana ummangalelo wokuqala ngathi alibaleke ityala kuba kaloku ayikhona incoko efowunini phakathi kwammangalelwa u-station commander ebuza umnumzana uGotyi ukubana uphi umfi, kwaye wamcela ukuba ke athi andwendwele i-police station, kodwa ke umnumzana uGotyi azange ayindwendwele i-police station. Kwaye ngeli xesha bukhona nobungqina bukammangalelo wokuqala ukubana caretaker waye wamazisa phambi ubana athi yena azibulale ukuba yena nguye obulele uKungawo. Kwaye inkundla ayinelisekanga zizicwangciso ezithe zafakwa ke ngu-Advocate Stemba ukubana kutheni engakhethanga ukubana athi azikhulule kuloo nto ngokuthi afowunele umphathi wesikhululo samapolisa. U-Advocate Stemba waphakamisa into yokubana ke ummangalelo wokuqala wayephukunyezwa ngokwasemoyeni ukhetheka emcenga ukubana ke angamxeli. Kwaye ke ummangalelo wokuqala waye wathi ngoko nangoko wafowunela umnumzana uDakata. Kwaye u-Advocate Stemba waphakamisa ukubana bonke obu bungqina buze apha enkundleni buziswe umphandi wetyala. Kwaye obu bungqina bonke uthatha kumnumzana uGotyi. Kwaye ke umnumzana uGotyi yena uyawuske athi xana ubana inkundla yamnika le bheli uyawuske athi ayohlala kwenye indawo angahlali apha kuba uyoyika ukubuyela kwesaa sikolo bephandle.
Thank you. Yes, Mr.
Your Worship, before I go into arguments, Your Worship, I wish to remind this court about the purpose of bail. It is common cause in fact law that the purpose of bail is not criminal in nature. We are not here today to determine the guilt or the innocence of applicant number 2, Your Worship. The inquiry that is relevant here is whether an attendance for trial can be secured, Your Worship. Your Worship.
You are reminding me.
Yes.
Have I forgotten about it?
No, Your Worship, just to, for what purposes, Your Worship?
No, I know the purpose of the application. That's why I'm sitting.
Court, please, Your Worship. Your Worship, in Schedule 6 bail applications, Your Worship, there is a heavier onus on the applicant to try to convince the court that exceptional circumstances exist which in the interest of justice permit for evidence. This is a two-legged test, Your Worship, and for you to go to the second test, we have to satisfy that exceptional circumstances do indeed exist, Your Worship. Your Worship, now, it is also quite law that the term exceptional circumstances is not defined by the legislature, Your Worship, but there have been numerous cases that have shed some light on what can, in certain circumstances, qualify as exceptional, Your Worship. Your Worship, there's a case of State versus Potten and others from 2004, Your Worship. In paragraph 58, it was said that the evidence of an investigating officer that the bail applicant was not a flight risk, not likely to interfere with the state witnesses and investigation, led the court to the conclusion that the bail applicant had discharged the onus which rests on Your Worship in terms of Schedule 6. Your Worship, there is further case law from State versus DV and others. There's a 2012 judgment, Your Worship, at 8.
Sorry, what's the citation there?
State versus DV and others, 2012,
Yes.
in brackets 2, close bracket SACR 492, in brackets GNP. Yes, Your Worship. The fact that the state's case was subject to some doubt constituted exceptional circumstances. Now, Your Worship, I will come to why I say the strength of the state's case is subject to doubt. The last case, Your Worship, that I wish to make reference to is Moy versus the state. In brackets, Your Worship, 162/12, close bracket. A 2012 case, Your Worship, from the Supreme Court of Appeal. It was decided on the 30th of May 2012, where the presiding officer said that the delay by the state in concluding investigations, taken together with the deduced weakness of the state's case, constituted exceptional circumstances which, in the interest of justice, permit the release of the accused, Your Worship. Your Worship, furthermore, the fact that the investigating officer was unable to advance proper reasons for refusing bail, this also constitutes exceptional circumstances. As according to the state versus eDikeni case, it is unreported, Your Worship, but the citation is GSJ case number A134, stroke 2013, close bracket, Your Worship.
Yes.
Yes, Your Worship. Now, it begs the question as to what are applicant number 2's exceptional circumstances, Your Worship. Your Worship, firstly, the investigating officer said during a cross-examination on 26 September 2024 that applicant number 2 has a verified address, which is not a false address. She never resisted arrest and she will not interfere with the state investigation. That is the first exceptional circumstance, Your Worship. Moreover, Your Worship, what can also constitute exceptional circumstances is that the investigating officer also said that DNA results will be ready in 15 days from 26 September 2024. This is the 7th working day after the investigating officer made that submission, and we are still in the dark about the readiness of the DNA results. I therefore invite my learned colleague, the state, to provide us with an update in her closing arguments, Your Worship, regarding the readiness of saying, I put it to the investigating officer that the results will not be ready in the next 6 months. And if the results are not back by 17 October 2024, that will amount to an unjustifiable violation of applicant number 2's constitutional right to fair and speedy legal proceedings and her right to liberty, Your Worship. That violation constitutes exceptional circumstances which, in the interest of justice, permit her release on bail, Your Worship. Your Worship,
What is the lifespan of a case in the district court?
6 months, Your Worship.
When was this offense committed? Allegedly committed?
July, Your Worship.
So the lifespan of this case in this court will be January 2025, right?
Yes, Your Worship.
Make the name.
Okay, Your Worship. Now, Your Worship, when I said that there's some serious doubt on the strength of the state's case, this is what I meant, Your Worship. When I asked the investigating officer about any form of evidence that links applicant number 2 to the commission of these alleged offenses, she said there's no evidence, Your Worship. Specifically, her version of how this offense allegedly transpired is obtained from accused number 1. She said that accused number 1 made an oral statement to her. Now today we have statements from the occurrence book that says now in that occurrence book it is actually applicant number 1 with Kungawo. But in testimony, Worship, in evidence in chief, she said it is applicant number 2 with Kungawo, Worship. So that discrepancy throws doubt on the strength of the state's case, Worship. Furthermore, Your Worship, it begs the question as to which independent investigations did the investigating officer carry out to satisfy herself there's a strong case against applicant number 2, Your Worship. Moreover, when applicant number 2 has submitted in an affidavit that she has a cast iron alibi, which is applicant number 3, who also corroborated her version under oath.
That he has got an alibi.
No.
Who has got an alibi?
Applicant number 2, that she was at Tata's tavern with applicant number 3.
Did you listen to applicant number 2's oral evidence when you took over this matter?
Yes, Your Worship.
The whole of it.
Yes, Your Worship.
Was that alibi raised when she gave evidence? And did she raise alibi?
No, Your Worship. She raised it after I had taken over.
What do I do with that? Now that when you took over, she raised the alibi in an affidavit. What must I do with the oral evidence that she raised before this court and there was no alibi?
I'm not saying to this court that her oral evidence must be dispensed with.
No, what must I do with that?
It can be taken into consideration, but I did address this on the court when I took over, Your Worship, that there was some information that was not accurately put to the court before I had taken over. And that piece of information was supplementing the oral evidence, Your Worship.
And you know for a fact that what you say when you are under oath carries a lot of weight compared to what you say in your affidavit. Because when you are under oath there, giving testimony, you can be cross-examined, but your affidavit cannot be cross-examined. Not so. So what I'm trying to say to you is that what he said, what she said under oath carries a lot of weight compared to what she said in the affidavit. Because whatever that she said in under oath, there, when she was giving testimony, she was cross-examined. Unlike what she said in the affidavit, because that was not cross-examined.
What is this, Your Worship?
I'm going to invite you to what was said in Matebula. Have you read Matebula?
Regarding the strength of the state's case, Your Worship.
Yes, regarding the state, regarding the strength of the state case, but also exceptional circumstances. In that Matebula case, if my memory serves me well, Mr. Matebula did not give oral evidence, and he sought to attack the state case in the affidavit. Right? That affidavit was not cross-examined. And in my view, all the facts that Mr. Matebula had or came up with during that bail application in the affidavit, in my view, if he had said all that he said in the affidavit under oath, I don't think he would have taken the matter up to the SCA. Because in my view, all those things that he said, he was a business person. I mean, to me, that was exceptional. But he attacked the state case now in an affidavit. And he appealed up to the SCA in vain.
Well, Your Worship, that is not the only exception.
I understand.
Yes.
I understand.
That is not the only exception that we are advancing. If the court, and rightly so, if the court wishes to take the oral evidence and give it more weight compared to the, which is
more likely to happen.
Yes.
Because when you are cross-examining, when you are under oath there, yes, I know affidavit is done under oath as well. I
Yes.
know. But when you are giving evidence, viva voce, you are saying, court, I'm taking you into my confidence. I will withstand cross-examination. Understand? And that's what she did earlier on, before you even came into the picture. She took the stand, she testified, she was cross-examined. Then when you took over, you then made an application for the reopening of a case, which was granted. And then you submitted an affidavit. Now, the cast alibi came now through an affidavit. Hence, I'm now saying, I'm concerned. I'm not saying I'm going to disregard. I can't disregard the affidavit. It's made under oath.
Yes.
But now I'm concerned because she had ample time to raise this when she was testifying, but she opted not to. Do you see where I'm coming from?
I do agree with this one, Your Worship. It is tight though.
Yes.
Yes, Worship, but just to close off on her exceptional circumstances.
Yes, yes.
It's not just one that I'm trying to prove. The cast iron alibi is merely one of 2, 3, Your Worship. But the fact that she is not a flight risk is an exceptional circumstance. Backed up by case law, investigating officer also said she will not interfere with the state witnesses or investigation, not a flight risk. Thank you, Your Worship. Now, Your Worship, now that the first leg of the test, exceptional circumstances, has been proven, has been triggered, now we can move over to whether the interest of justice permit for her release. Section 60, subsection 4, subparagraph A to E then finds application, Your Worship. And should any of those likelihoods be proven to be likely, then bail must be refused. Type Your Worship. When you go to section 60, subsection 4, subparagraph A, I asked the investigating officer, Your Worship, whether this likelihood is possible, and she said yes. I probed her further and asked her, she said it is likely to occur because applicant number 2 might find another boyfriend and suffer from low self-esteem, which might drive her to commit another offense. With all due respect, Your Worship, this is not a reason that can hold water. It is not based on a point of law. Applicant number 2 has no...
It's based on speculation.
Speculation. And as the court said in State versus Diane and another, 2013, it's a High Court judgment where in paragraph 14, it was said that there must be a finding on probabilities that this likelihood will occur. We cannot merely speculate or hope in the dark. Applicant number 2 has no previous convictions, no pending cases, no violent disposition, Your Worship. It is therefore why we submit, Your Worship, that this likelihood will also not occur, Your Worship. She has never been arrested before. Where does the investigating officer get the impression that this likelihood might materialize? Your Worship, when we go to section 60, subsection 4, subparagraph B, applicant number 2 has stated that she has no passport, she has never absconded from a court appearance when out on bail, being the first time being under arrest, Your Worship. She has no incentive to evade trial, Your Worship. Even the investigating officer, once again, has said that she's not likely to abscond, she's not likely to, Your Worship. Your Worship, I will not waste time on this subparagraph because even if the court were to impose bail conditions, they can be easily enforced, whether she is residing at her primary residence in Alice, a golf course, or she's in Port Alfred at her alternative address. They can be easily enforced. The investigating officer also said she never resisted arrest, Your Worship. When we look at subparagraph C of section 60, subsection 4, Your Worship, once again, the investigating officer said she's not likely to interfere with the state investigation or state witnesses. She does not have access to the state docket. She does not know which evidence the state may have against her, Your Worship. Your Worship, when we look at subparagraph D, it is common cause that applicant number 2 fully cooperated with the police as confirmed by the investigating officer during cross-examination. She has never supplied false information to the police during arrest or to this honorable court during bail proceedings. She has no history of failing to comply with bail conditions, Your Worship. She has never been arrested before. She's not on parole. She's not in custody for another charge, Your Worship. The issue regarding the petition, Your Worship, I have to address the petition in that these allegations that the applicant is faced with are indeed serious in nature. There is a petition with over 1,000 signatures, but what proof is there before court that the release of applicant number 2 will cause public disorder or outrage in the community where the offense was allegedly committed? All we have today is full gallery, no demonstrations or protests outside of court. The petition itself does not contain any threats from the signatories, so there's no danger to the safety of applicant number 2 if she will get released on bail. Your Worship, the signatories merely say that they do not wish for applicant number 2 to reside in their community. This community is Alice Mavoso Golf Course in Tselamanzi. Applicant number 2 has provided an alternative address in Port Alfred, Your Worship, where her aunt resides. It is over 150 kilometers from the community.
Has it been verified by the investigator?
Your Worship, I put it to the I asked the investigating officer whether does applicant number 2 have a verified and fixed address. She said yes.
The one in Port Alfred was verified. Was it verified?
The one in Port.
Which one are you talking about?
The one in Port Alfred, Your Worship, if I remember correctly, Your Worship, it was not verified. But it is not to say because it was not verified, it cannot be verified now. The court has at its disposal section 60, subsection 3, to make an order, Your Worship, that the investigating officer goes there to verify this address, Your Worship. it is not too late to verify, Your Worship. Now, Your Worship, yes, it is over 150 kilometers from Alice, Your Worship. Yes. So her safety is secure, Your Worship. If this court orders that she goes and resides there, there will not be any problems on her part.
So I should grant bail on applicant number 2 and order that she should go and stay in Port Alfred pending translation of this. Is that what was?
Yes, Your Worship. The court, in fact, we encourage the court to do that, Your Worship. Yes. Now, Your Worship, she is even able to report at the Port Alfred police station on a weekly basis if the court also orders same. Yes, Your Worship. Now, regarding the petition, the court should rather use this opportunity, Your Worship, to educate the community of Alice and the broader public that the mere submission of a petition is not enough to trigger this likelihood. We must look at where the signatories are from, whether the applicant has an alternative address, whether any threats were made against the applicant and the family, and whether, if there were any threats, whether those threats carried out, Your Worship. Your Worship, the public will not lose confidence in the criminal justice system, because in this specific bail application, there is no compelling reason not to fix bail, Your Worship. We are not here today to determine the guilt of the applicants, but rather to determine whether the attendance for trial can be secured, Your Worship. Your Worship, her personal circumstances are also before court. She is 20 years old, Your Worship. She has no previous convictions, no pending cases, no arrest warrants outstanding against her name, Your Worship. Like I said, Your Worship, the fact that there's no compelling reason not to fix bail in this matter, Your Worship, qualifies as an exceptional circumstance, Your Worship.
What must I do with her involvement in the commission of the offense as it was detailed by the investigating officer? That if in herself, when she was giving testimony, what must I do with that? When there, upon being requested by one, fetched, condemned, so deceased, we proceeded. And there's evidence now by the investigating officer that I don't know whether it was a hockey stick or what, but she participated in assaulting the deceased. What must I do with that?
In actuality, Your Worship, it was a hose pipe that was allegedly used. But the investigating officer said that hose pipe was not found. A hockey stick and a burnt panga were found. Yes, Your Worship. And even at this stage, Your Worship, those items have been sent for DNA testing. We cannot say at this stage, Your Worship, that she is the one who carried out those assaults. And even in a bail application, Your Worship, she has, to her defense, paragraph 27 and 28 of Chisani vs. State, it's a 2022 Makanda High Court judgment. It says in a bail application, she's not under any obligation to prepare a proper basis for defense, Your Worship. Your Worship, I do respectfully note the investigating officer's submissions in terms of how she's linked to the offense. But I also pose questions to her, Your Worship. Even the occurrence book that is before court today contradicts what she was saying viva voce, Your Worship. So I would also like the court to look into those discrepancies, Your Worship. Yes, Your Worship. If there are any further questions from this honorable court, Your Worship, I am happy to answer.
How much bail can she afford?
She said, Your Worship, that in her affidavit that she, I remember, if you can just check, Your Worship, that she could afford an amount of 1,000 rand. Yes, 1,000 rand, Your Worship. But the court can be flexible, Your Worship, but bearing in mind the affordability of the second.
I've seen bail applications being fixed at 100,000. I've seen, not so long ago, last week, I can mention a court that fixed bail at 100,000 last week.
But in that case, Your Worship, it would be better for bail.
Are you aware of that case?
No, Your Worship.
Okay.
It would be better for bail for a bail to be fixed than for it to be refused because she cannot afford any bail amount. But she has advised this court that 1,000 rand she can definitely pay. If this court wishes to up the ante, Your Worship, she will make means. Unfortunately, she has to, Your Worship, in order to get a freedom grant, Your Worship.
Thank you.
Court, please, Your Worship.
Can you summarize that?
Kwetha kamanga lelo wesibili lapha kama lapha kamsukulalelayo kubana ke ikhumbuza inkundla ukubana ke isizathu ukubana kufakwe isicelo sebheyili ukubana ke akufuna ukuthiwa ukubana kuboniswa umuntu uba unetyala okanye akanatyala kodwa ke uxanduva olulele umangalelwa ubana abonakalisa uba zikhona iimeko ezikhethekileyo ezithi ngomda wobulungisa zivume ukubana yena akhutshwe ngaphandle ngebheyili. Latsho lacaphula ke phaa kwityala phaa kumbuso noPortland nabanye ityala ngo-2004, caphula netyala phaa kumbuso no-DV nabanye lango-2012 isithi ukuba umbuso into yoba ityala lombuso iyathandabuzeka, imeko ekhethekileyo leyo. Kwaye kwacaphula phaa netyala phaa kumbuso noMoyi lango-2012 kuba uthi umphandi wetyala akakwazanga ukuba abeke isizathu esivakalayo sokuba iphikisa ummangalelo wesibini akhutshwe ngaphandle ngebheyili, naleyo yimeko ekhethekileyo ngakummangalelo wesibini. Kwaye ephakamisa ukuba ngomhla we-26 kaSeptemba 2024 kwaye kwavela ukuba ummangalelo wesibini unayo idilesi ebambekayo kwaye akangumntu nothi alibaleke ityala. Waphakamisa nento yokubana ke kuthiwe kolu phando kulindwe neengxelo ze-DNA ekuthiwe ziza kubuya emva kweentsuku eziyi-15 ukusukela ngalaa mhla we-26 kaSeptemba. Kodwa ke wathi ukuba ezi results bekumele uba zibuye phambi kokuba ube ngumhla we-17 kaOkthobha. Uthi into ayawuyibona isenzeka leyo kuba uyayiqonda ziye zithathe ixesha lingaphezu kwenyanga eziyi-6. Kwaye uthi uyayithandabuza kakhulu into yokuba umbuso unetyala eliqinileyo ngakummangalelwa wesibini kuba umphandi wetyala akanabungqina buphathekayo okanye obonakalayo obubophelela ummangalelo wesibini ngaphandle nje kobungqina obo buthethwe athi umphandi wetyala buthethwe ummangalelwa wokuqala kuye. Uthi makuqwalasela nalaa ndawo yokuba kuthiwa ekuqaleni kuthiwe ummangalelo wesibini waye waqhuba imoto enyathela ukungawo. Kodwa ke ngoku apha kuyingxelo ezisandungena ngoku kukho ubungqina wokuthi uba yaba umzwandile Tyanki owathi waqhuba le moto. Uthi naleyo yimeko yinto emayijongwe njengemeko yenye yeemeko ezikhethekileyo ngakummangalelo wesibini. Esithi makuqwalasele into ummangalelo wesibini wayethetha phambi kwezifungo. Inkundla ibuza ke ngaloo nto wathi uba inkundla ifuna ukuqwalasela loo nto uba into ayithethe phantsi kwezifungo ithelekiswa nento ayibhale kwi-affidavit, ubana loo nto ithathwa njengento enexabiso elingaphezulu kunenye, inkundla ingathi ke ithathe le nto ayithethe phantsi kwezifungo njengento evakalayo kuyo kakhulu. Kodwa ke uthi ucela inkundla zikhe iqwalasele phaa kwityala phaa komathebula kombuso nomathebula apho umathebula waye wafaka isicelo sakhe ngaphambi nge-affidavit. Athi inkundla mayiqwalasele ubana imeko kammangalelo wesibini ekhethekileyo uba akazukuthi alibaleke ityala kwaye xa sokuqwalaselwa phaa iimfuno zobulungisa ku-section 60 ibakala u-4A uba ummangalelwa lona akanawuthi ingaba ungumntu onokuthi aphinde enze eli tyala na. Uthi ke ummangalelwa umphandi wetyala waye waphakamisa ukuba ummangalelwa lona angathi aphinde elenze ityala elinjena. Mhlawumbi umzekelo angathi athandane nentombi akhwelete afune ayibulale ngaloo nto leyo. Kodwa lake lithi ke undiva lowo kuba kaloku akukho nto itshoyo kwangoku uba kuye obuleleyo na. Kwaye ummangalelo wesibini azange wagwetywa kwaye akanawo amanye amatyala awaxoxayo. Loo nto ingambangela mhlawumbi abe ngumntu onolibaleka ityala lakhe. Phinda esithi phaa kwi-section 60 subsection 4B ubana akazulibaleka ityala kwaye section 64C akazuthi aphazamisane nophando, akazuthi aphazamisane namangqina. Kwaye esithi uba akuqwalasele into yobana ngelaa xesha wayebanjwa azange athi asokolise amapolisa ukubana angafuni ukubanjwa kwaye akakho ngaphandle kwemiqathango yengqawe. Phakamisa ngokubana ke kwezaa zicwangciso zabahlali sibekhala izanto zifakwe apha enkundleni ngabahlali bekhala esithi ubana bangawunikwa epeyili. Uthi uyawabona ubana bangaphezu kwekwakhe abantu abatyikityileyo phaya, kodwa ke akho bungqina ukuba ummangalelo wesibini nothi akhululwe ngaphandle ngepeyili. Loo nto ingathi idale isankxwe kuba phaa kwezaa zicwangciso zifakwa ngabahlali apha enkundleni akhange bekho zigrogriso uba umangali ezinothi umangalelo wesibini ukube kanti usesichengeni ubani lokuhlala. Kwaye umangalelo wesibini uzawuthi afuduke ayokuhlala ePort Alfred apho uzawube ekhuseleke khona. Kwaye angathi inkundla ibeke umqathango wokuba ayo emapoliseni ayosayina qho ngeveki. Kwaye ke inkundla iqwayasele le nto yokubana le petition ingakhange ibe nazo ngokrizo. Kwaye iimeko ezikhethekileyo zikamangalelwa ezinye magxola sembana uneminyaka eyi-20, uyintombazana eneminyaka eyi-20, azange wagwetywa, akho tyala lingelinye alixoxayo. Kwaye inkundla yabuza inkundla ubana ithini ke ngoku yona ngale nto abandakanyeka ngayo kwesi senzo sokophula umthetho. Phendula igqwetha athi okwangoku akakafunyaniswa enento aye bekanti ukuthiwa uyenzile isemundiva wonke. Kwaye waphakamisa into yobana ngathi akwazi ukukhupha imali yepeni engange-R1,000.
Yes, Mr. Nutani.
Complex worship. The applicant before court to worship, which is article number 3, is facing an offence which falls under the ambit of Schedule 6. And what this bail applications of this nature are governed by Section 60, subsection 11 of the Kungawo Act. And what this means is that the onus rests on the applicant to demonstrate to the court that there are exceptional circumstances which, in the interest of justice, permit her release on bail. And in her attempt to discharge the necessary onus, the applicant took the stand, and her evidence, Your Worship, I am not going to repeat to this court, as it is still fresh in our minds. The investigating officer also testified before okay, as she was opposing the release of applicant number 3, and her reasons, Your Worship. I will only highlight a few things from the evidence of both the applicant and the investigating officer, which I believe are relevant for the court to consider. The purpose of bail, Your Worship, it is to secure the attendance of the accused person until her case is finalized. It should not be used as a form of anticipatory punishment. Applicant number 3, Your Worship, is facing 2 counts, Your Worship. One count being that of kidnapping, and the other count of murder, Your Worship. And the evidence that was led before this court regarding the charge of kidnapping, Your Worship, I believe, Your Worship, fell short to prove a prima facie case, Your Worship, of kidnapping. And the evidence before this court is that applicant number 2 and 3 went to ask for the deceased at her house. There was a deceased friend who was present at the time when they arrived. There is no evidence, Your Worship, that there was resistance from the deceased or that there was force used to take care to applicant number 1's withdrawal. Therefore, Your Worship, one cannot conclude that applicant number 3, Your Worship, kidnapped the deceased. And Your Worship, on the charge of murder that is preferred against applicant number 3, the IO gave evidence, Your Worship, of how applicant number 1 assaulted the deceased with a panga. It was her evidence, Your Worship, that applicant number 1, together with the husband of applicant number 3, Your Worship, they carried the body of the deceased whilst applicant number 2 was instructed by applicant number 1 to drive the motor vehicle over the deceased body. However, Your Worship, there is no participation from the applicant, from applicant number 3. The IO further testified that applicant number 3, what she did was to assist in the planning of the board by fetching the tires. And one, Your Worship, would rather be curious and ask Your Worship that, is there a charge of defeating the ends of justice preferred against applicant number 3 to justify what the IO testified regarding the participation of applicant number 3. The evidence that was mentioned by the investigating officer that the case of the state is solely reliant on the DNA and the confessions. But I want the court, Your Worship, to take into consideration that when she took the stand, Your Worship, have testimony, Your Worship, she said it herself that it was mostly from what she heard from applicant number 1. Now, Your Worship, that alone, Your Worship, raises doubts as to why an investigating officer will come and testify of serious allegations, Your Worship, against the applicants and oppose bail, Your Worship, relying on the evidence that he got from one of the people who are implicated in the commission of the offense, Your Worship. I also want the court, Your Worship, to consider, Your Worship, that the investigating officer, Your Worship, misled this court, Your Worship, and said that the DNA, Your Worship, will be available in 15 days, Your Worship. Which we all know, Your Worship, as people who work in the criminal court, Your Worship, we are faced with a challenge, Your Worship, when it comes to DNA results, Your Worship, and matters that involve DNA, Your Worship. Therefore, Your Worship, it would be incorrect, Your Worship, to say that it is a matter of days before the DNA, Your Worship, is made available. Your Worship, I would like to invite the court to the case of State versus Mazbuko and another, Your Worship. It is a 2010 decision, volume 1, SACR, where the court held that for circumstances to qualify as sufficiently exceptional to justify the applicant's release on bail, it must be one which weighs exceptionally heavily in favor of the accused, thereby rendering the case for the release on bail exceptionally strong and compelling. Your Worship, if one looks at the strength of the state's case against the applicant, Your Worship, it is very weak, Your Worship. The state will have a difficult time, Your Worship, securing a conviction, Your Worship, of murder or kidnapping in these charges, and considering the fact that the applicant took the stand, Your Worship, and she was firm and said that she intends to plead not guilty, Your Worship, when the matter goes on to trial. I would like to also refer to the case of Furi and the state. It is a 2020 decision. It is unreported. It is a decision of the North Gauteng High Court, Your Worship, where the court held that where the state's case is subject to some doubt, there being no likelihood that the accused person may interfere with the state witnesses, a low risk of re-offendering constitute exceptional circumstances. Now, Your Worship, I will move to the second leg of the test, Your Worship, which is the interest of justice. From the evidence presented, Your Worship, by the investigating officer to this court, Your Worship, there was no evidence, Your Worship, to suggest that there exists a likelihood that if applicant number 3 is released from bail, she will endanger the safety of the public or any particular person.
How was she arrested?
Your Worship, she was arrested whilst she was on her way to report that her deceased husband did not come back, Your Worship, from the previous day. May I continue, Your Worship?
Yes.
From the evidence of the investigating officer, Your Worship, there is no evidence before this court that if the applicant is released on bail, she will attempt to evade trial, or she will attempt to intimidate or influence or conceal or destroy evidence, Your Worship. Therefore, Your Worship, it is my submission that the applicant before court, Your Worship, has discharged the necessary honors, Your Worship, and Your Worship, she is a suitable candidate to the release outcome, Your Worship. That is all, Your Worship, and that's the point.
It's just one aspect. Was there any reason that was finished by number 3 as to why did she not report this incident to the police? That is not report what had happened or what had happened to the deceased to the police.
Your Worship, you mean in her evidence, Your Worship?
Yes, for instance, when she was arrested, she was proceeding towards the police to report
Yes,
that her child had not returned.
Yes, Your Worship.
My question is, why did she not deem it fit to go and report what had happened to the deceased now? Because she knew what had happened to the deceased. Not so.
Correct, Your Worship.
Then why did she not go and report to the police immediately?
Your Worship, as the court will remember, Your Worship, there is evidence that there are confessions made by applicant, Your Worship, before court.
2 and 3.
Yes, Your Worship.
Yes.
Therefore, Your Worship, I believe that through those confessions, Your Worship, they had, Your Worship, she had, Your Worship, tried to explain, Your Worship, or report, Your Worship, through those confessions, what had happened to the deceased, Your Worship.
No, I understand. The issue of the confession is something that transpired after the arrest, not so.
Yes, Your Worship.
Yes. My question is, as someone who was present from the taking of the deceased at her home up until whatever that happened in Grahamstown,
Yes.
she was aware of what had happened to the deceased. Then my question is, why did she prioritize the child who was not brought back when she knew very well that someone had passed on? Why did she not report this to the police? Why was she only concerned about her child? You understand where I'm coming from?
Yes, Your Worship.
Why was her main concern about her child? What about this person who was killed? Even if she played a minimum role,
Yes.
if I agree with you, even if she played a minimum role. And in fact, as far as the IO is concerned, she played a minimum role in this whole fracas.
Yes.
But be that as it may, she was aware now of what had happened to the deceased. Why did she not report this to the police?
Well, Your Worship, I cannot give the court a clear explanation or speak on her behalf, Your Worship. Maybe perhaps
No, it's
she was going to, when she was reporting her child, Your Worship, she was going to mention, Your Worship, what had happened.
Maybe.
Your Worship. Maybe.
Same question to you, sir. Same question.
Yeah,
Why did number two, your client, fail to report this to the police when she knew exactly what had occurred to the deceased?
At which stage, Your Worship?
Prior to her arrest,
I think it's not.
just before she was arrested. It's not time. How much bail can applicant number 3 afford?
Your Worship, in her testimony, Your Worship, she did mention that she is no longer working. She was dependent on the deceased husband, Your Worship. Therefore, worship, she did mention that she will not be in a position to raise being worship, but I did have a word with one of the relatives worship. I believe worship, some of other clients worship. Will be an amount of worship that we can raise worship.
Okay. Yes, sir.
Worship, she instructs that she did inform the police of what had transpired in worship. This is when at the police station, this is when the confession statements were taken in worship. That she says
So that's after the arrest.
yes, worship. Yes, worship. And the reason she could also not make any phone call to the authorities after leaving Grahamstown on their way
Yes.
to Ellis, so forth,
Yes.
was because, as she instructs, that she did not have the phone with her, and immediately upon arriving in Ellis, she did not go immediately home. She was at the premises of number 1. But upon arriving at home and the police took her, worship, at the station, she did cooperate with them. She told them everything, worship. Yes, worship.
Okay. Yes, Ms. Timms.
Thank you, worship.
Kwalikamangalo wesithathu laphakama lafaka-ke izicwangciso okanye ingxoxompikiswano enkundleni. Isithi-ke ityala elijongene nommangalelo wesithathu likwakuluhlu lwamatyala kaShedule 6 ke kwizicwangciso zebheyile, kwaye apho-ke uxanduva lulele kummangalelwa ukuthi abonakalise le nkundla uba zikhona iimeko ezikhethekileyo ezithi ngomdla wokulungiswa ukuba makakhutshwe ngaphandle ngebheyile. Ummangalelo wesithathu waye wafaka ubungqina apha enkundleni ngendlela yokuba athethe phantsi kwezifungo, kwaye nomphandi wetyala ke uye wenza ngokunjalo nazo. Ke isizathu sokubana kube kanti kukho iingxoxo zebheyili ayikokubana ke kufunyaniswe umntu enetyala okanye hayi, kodwa ke kukokubana kuqinisekiswe ukuba umntu uzawuthi amane evela etyaleni lakhe de kube kanti ityala liyaqukunjelwa. Ummangalelwa wesibini ujongene nezityholo ezibini, ityholo eso sokuxhila kwakunye nesityholo sokubulala. Ke ubungqina abulapha enkundleni ngokuphethelene nokuxhila oko awukwazanga ukubana kuyanele kanti ubungqina obonelisayo, kuba ke umfi lo wayenogxa wakhe endlini ngeli xesha ke eyolandwa ngummangalelwa wesithathu. Kwaye ke akho bungqina buthi ukuba kwabakho ukuthathwana okanye ke kwathathwa ngenkani. Kwaye kwesityholo sokubulala akho bungqina ukuthi uba ummangalelo wesithathu wadlala indima enkulu. Kwaye ke uthi ngokutsho komphandi wetyala ubungqina buthi ummangalelo wokuqala waye wathi ummangalelo wesibini makaqhube imoto enyathela ke lowo umfi lowo. Kodwa ke akho nto ithi uba ummangalelo wesithathu wadlala iphi indima, kodwa indima nje ayidlalileyo ilapho ukuba uncedisile ngexesha kutshiswa umzimba. Kodwa uthi apha enkundleni akho zityholo zithi izityholo ezo ukuthi ke uphikisana nengalo yomthetho. Kwaye inkundla okanye umbuso uxhomekeke nje kuphela ke kwiinkcukacha okanye kwizitetimenti kwakunye nakwingxelo ye-DNA. Qha awukho bunye ubungqina obunye buphathekayo. Kwaye kutheni le nto umphandi wetyala eze apha enkundleni aphikise ibheyili kubantu abatyholwayo kodwa akho bungqina buqinileyo okubabeka kwisenzo, okubabophelela kwisenzo eso solwaphulomthetho. Umphandi wetyala uyixolisile ngenkundla ngokuthi iinkcukacha okanye iingxelo ze-DNA izawube sezilungile ngeentsuku ezi-15 usukela ngalapha kwe-26 kaSeptemba. Loo nto bubuxoki. Watsho ecaphula ke kwityala phakathi kombuso ojongene noMazuluko nabanye ityala ngo-2010 esithi ityala lombuso apha aliqinanga kwaphela tu. Kwaye ummangalelo wesithathu akananjongo zokudluma ityala xa sele kuxoxwa ityala. Wacaphula ke netyala phakathi koFori ejongene nombuso, ityala lika-2020 laxoxwa phakathi kwinkunde yaseRhawutini. Apho kuthiwa ukuba ukubana ke ityala lombuso elo liyathandabuzeka, ummangalelwa lowo icacisa lo mbana ummangalelwa, kwaye ummangalelwa akangumntu ugrogrisayo okanye ngothi kanti uyingozi kuluntu. Loo nto leyo yimeko ekhethekileyo iyodwa nje. Kwaye ummangalelwa wesithathu akangumntu funa ukuthi kanti ube kanti uyingozi eluntwini bayakukunqina ukuba umali wesithathu angathi alibaleke ityala angonyamelo okanye azame ukonakalisa okanye afihle ubungqina. Buza inkunzi uba ingaba sikhona isizathu suka kumangalo lwesithathu uba kutheni le nto engazange axele emapoliseni ukuba kwaye kwenzeka ntoni womfi phambi kokuba kanti uyabanjwa. Igqwetha lakhe laphakamisa ubana ke ezo zinto zawuthi zicace kakuhle xa kunothi kuqwalaselwe yile nkundla ezaa nkcukacha ze-confession ezenziwe ngummangalelwa wesithathu. Kwaye inkundla yambuza ubana kutheni le nto ezawuqala ngokubana athi ayoxela umntana wakhe ungabelanga endlini angaceli lesi sehlo yena sibonileyo sokubana kwenzeke ntoni ngomfi. Igqwetha laphakamisa ubana ke kuyabonakala ngomphandi wetyala ukuba ummangalelwa lo incinci kakhulu indima ayidlalileyo xa kwesi senzo solwaphulomthetho. Kwaye ke uphakamisa into yoba imali yebheyili angathi akwazi ukuyiza nayo apha enkundleni imali engange-R500.
Yes. Samo?
Indeed, Your Worship, this bail application falls under Section 60, 11A of the Criminal Procedure Act. And also, Your Worship, the duty solely rests on each applicant, Your Worship, to prove their case on balance of probability, Your Worship, and no duty is placed upon the state. I will start with applicant number 1, Your Worship. The applicant, Your Worship, stated that he wants to be released out on bail because he wants to go back to work and take care of his children. However, Your Worship, he is not the primary caregiver of both his children. Their respective mothers are. They also, Your Worship, do receive child care grant, as he stated. With regards, Your Worship, to his employment, the applicant is suspended by the Department of Education. He was indeed, Your Worship, served with papers stating saying, even if, Your Worship, he can be released out on bail, there is no employment for him to go back to until this case is finalized. It was the evidence of the investigating officer, Your Worship, that the applicant is a flight risk. The station commander, Your Worship, did a courtesy of calling the applicant to come to the police station regarding the disappearance of the deceased, and Your Worship decided not to go. He left Alice, Your Worship, and was later arrested at Ingwe. At the scene, Your Worship, the investigating officer did state, Your Worship, that the tracker was taken out of the car. This is a clear indication, Your Worship, that he did not want to be found. There were also, Your Worship, 2 ropes that were found at the scene. According to the investigating officer, Your Worship, it is believed that he was going to hang himself. Why would someone, Your Worship, want to hang himself if he did nothing wrong? It is clear, Your Worship, that guilt was eating him up. When he received the call, Your Worship, from the station commander, I believe that he panicked. And he and the natives one day, Your Worship, decided to run away. There was also a name, Your Worship, of Mr. Dagada that we only heard about when the investigating officer was being cross-examined. We did not hear such evidence, Your Worship, from the examination chief when the application was being lied, Your Worship, by the attorney. And Your Worship, he also lied before this court to state that, Your Worship, there were 6 in the car. There was also another person called Baukas. However, that was disputed by applicant 2 and 3, that there were only 5 in the car. There was no person called Baukas inside the car. And he also, Your Worship, mentioned that he did not take part in the killing of the deceased. However, it was the evidence of applicant number 3, Your Worship, that the accused person, or applicant number 1, that Your Worship, did assault the deceased person. The applicant, Your Worship, cannot be trusted by this court, as he misled this court, Your Worship, so many times. Section 60, subsection 4, Your Worship, states clearly that bail should be refused if there is a likelihood that the accused, if he is released out on bail, will evade his trial. Also, section 60, subsection 8 states that, Your Worship, in considering whether the grounds in subsection 4 has been established, the court may, where applicable, take into account the following factors: the fact that the accused knowingly false supplied false information at the time of his arrest or during the bail proceedings. Therefore, I believe, Your Worship, that he is a flight risk and he indeed, Your Worship, supplied false information before this court. I will refer-
So that's number one.
That's number one, Mr. Worship. I will refer this court, Your Worship, to the recent case of Nandi Kungawo, where Your Worship bail was opposed and the speaker stated that she is a flight risk. The judge, Your Worship, in that case referred to the case of State versus Hudson. It's a 1980 case, volume 4, at page 145. It was held that, Your Worship, when accused applies for bail and confirms on oath that he has no intentions of absconding.
Did she eventually apply for bail? But the last time I checked, she was still challenging the arrest. Did she eventually apply for
She did, Your Worship, and this is the judgment.
Makutumani?
Yes, Your Worship. It was held, Your Worship, that when an accused applies for bail and confirms on oath that he has no intentions of absconding, due weight should be given to his testimony. However, implicit reliance cannot be given on the mere dicit of the accused. The judge further referred to the case of State versus Thornhill, it's in 1992, volume 2, where it was stated, Your Worship, that reliability of such a statement must be assessed in the light of the other established facts. Your Worship, the facts that I have already alluded before this court. I will proceed to applicant number 2, Your Worship.
So just one. Yes, you proceed.
The applicant, Your Worship, stated that she wants to be released out on bail because she wants to go and help her mother with the running of the crèche. However, Your Worship, it was the evidence of the investigating officer that she is constantly not at home. She is mostly applicant number 1, Your Worship, dated. Meaning, Your Worship, that her mother does not need her with the daily runnings of the crèche. She gave evidence, Your Worship, of care and later on submitted in affidavit. I also believe, Your Worship, that she is not someone that can be treated by this court. At first, Your Worship, she did not answer most questions that were posed into her, and also only in her affidavit, Your Worship, that we heard about Tata's Tavern. She never mentioned, Your Worship, this during his evidence review of her. She also stated, Your Worship, that she did not participate in the killing of the deceased. However, Your Worship, the investigating officer mentioned that she did, in fact, assault the deceased, and she even ran the deceased, Your Worship, over with the car of applicant number 1.
What's your take on what is contained in this document? That it was not known, it was Zwangi who ran over the deceased.
And that is the information from the third party, Your Worship.
From whom?
From the person that went to report in the police station. It was relayed to the police office, but the investigating officer had this information at first hand from the applicant.
So you're saying what the investigating officer was saying, it was from directly
From the applicant.
applicant number 1.
Indeed, Your Worship. And this information is from a third person that relayed it to the police office. Also, Your Worship, the applicant made a formal confession and stated that, Your Worship, she made that confession freely. She said she was not forced to make say. With respect to applicant number 3, the applicant stated that, Your Worship, she wants to be released out on bail because she wants to take care of her child as she has a minor child. She did not get a chance to bury her husband and she wants to claim the monies of her husband. However, Your Worship, according to the investigating officer, the child is residing with the sister of the late father and he is well taken care of. Also, he does receive child care grant. She also, Your Worship, made a formal confession.
Number 3.
Number 3. She stated herself, Your Worship, that the said confession was made freely and voluntarily.
Yes.
In that formal confession, Your Worship, the investigating officer even concluded that she assisted into looking for the tiles that were used to render the body of the deceased.
That is the only part that
And
she
that
did.
she participated on, Your Worship.
Now, we like to correct to suggest that the role that was played by applicant number 3 in the killing of the deceased cannot be compared to the role that was played by number 1 and 2.
Indeed, Your Worship.
Am I correct to
You are
suggest
correct,
that?
Your Worship.
correct?
You are correct. in that.
That the role that was played by number 3 in the killing of the deceased cannot be compared to the role that was played by number 1 and number 2.
Indeed, Your Worship, because number 1 and number 2 assaulted the deceased, and she did not. The only thing that she did was
To go and fetch,
the tires, Your Worship, to burn the body of applicant.
and even before the tires, she was present when the deceased was
fetched
being
from
fetched
the
from the
house.
place.
Indeed, Your Worship.
Okay. If I were to grant bail in respect of applicant number 3, and I'm not saying I'm going to grant bail, but I'm saying if I were to grant number 3 bail, what conditions would you suggest? What bail conditions?
I don't want to go to the granted by number 3, Your Worship.
You don't.
I
But I'm saying now, if I were to grant, I understand that you don't. It's your job as a prosecutor not to argue like that. I appreciate that, and you're correct. But now I'm saying, what if I decide to release her on bail? What conditions should I attach to that?
The court will decide the conditions, Your Worship. As I explained that I don't want.
Even if I say she must report at the police station once or twice a week, will that not suffice?
That will suffice, Your Worship.
That will suffice.
Indeed.
I'm not saying I'm going to release him on bail, but I'm saying if one has to consider Mr. Zara, the evidence in totality, in all fairness, the degrees of participation are not the same.
Indeed, Your Worship, but there was a participation in respect of
I agree.
applicant number 3.
I agree. She even made a confession freely. Yes,
Yes.
I agree. You are fighting that she must not get paid. You are fighting, eh? You are doing the job. You are doing the standing job. It's a good job to fight. I mean, you are representing the state. You must put up a good fight. But even if you fight and fight and fight, you know that at the end of the day, if she gets paid, you would have done your job. No one's going to come and criticize you. That means someone will fail. You would have done your job and a standing job. But it's not up to you now whether she gets paid or not. Not so.
Indeed, Your Worship.
Yes. Thank you very much. All right. Any submissions? Oh, you're not done. Okay. You may proceed.
Yes, Your Worship. I believe, Your Worship, that the allegations, Your Worship, are not exceptional. As per the required standard, Your Worship, by Section 16, Subsection 11A. I want to go to the state case, Your Worship.
Yes.
In the case of State versus Matimula, it was stated, Your Worship, that the function of the court is to assess the prima facie strength or weakness of the state's case and not to make a provisional finding of guilt or innocence. Therefore, I believe, Your Worship, that we do have a prima facie case against all 3 applicants before court. And, Your Worship, our case is very strong. As Your Worship, there is an eyewitness that saw them when they went to fetch the deceased at her house. The deceased was taken from the house, Your Worship, and she did not voluntarily go to Queenstown. And also, Your Worship,
She was forcefully taken.
indeed, Your Worship, she did not voluntarily go to Queenstown, the deceased, because there were different stops where the car was stopped and then she was assaulted. I do not believe that she went voluntarily to Queenstown. And also, Your Worship, it was the evidence of applicant number 3 that, Your Worship, the applicant number 1 did assault the deceased, and also the investigating officer did say that also applicant number 2 also assaulted the deceased. And on top of that, Your Worship, we have 2 confessions that were made by applicant 2 and 3. And such confessions, Your Worship, were made voluntarily by both applicants.
You know that those confessions may be challenged in the High
I understand, Your Worship, they can be challenged in the High Court, but now we are still dealing about the prima facie case. They can be challenged, Your Worship, I understand. But I believe besides the confessions, remember there was also blood that was found at inside the boot of the car of the applicant, number 1. The blood, yes, Your Worship, which was taken to the lab to confirm if ever the blood does match your worship with the deceased. And also your worship, there was the murder weapons, if I can call it like that, that were found, and the person that led the police to where those weapons were, worship, is applicant number 1, when he did the printing out. Therefore, worship, I believe that we do have a strong case, worship, against all 3.
Even if number 1 has got no confession,
Even if number 1 has got no confession, your worship,
you still maintain that you have a watertight case against him.
I still maintain it, your worship. Because he was there when the deceased was being fetched. It is the evidence of applicant number 2 that he assaulted the deceased.
Okay. Let's for a second, let's say in number 2's confession, of course, she mentions the role of number 1. I once came across a case law that says a confession is only binding against its owner unless the owner repeats what is contained in the confession when he or she is testifying under oath. So what I'm trying to say here is this. During bail application, a confession that is made by applicant number 2 implicating applicant number 1 during bail application. At this stage, I must not attach any weight to that. I must not. If there's a confession, I must confine myself to the confession and the maker of it, as far as he or she is implicating herself. The moment number 1, number 3, also number 2 says, number 1 played this role in her confession, I must not attach weight to that, because a confession is only admissible against its owner unless the owner during trial repeats what she said in the confession, that it is accused number 1 this time. So what I'm trying to say is that at this stage, I am going to look at applicant number 1's circumstances alone, without checking how is he implicated by applicant number 2 in the confession. And so is number 3 as well. So I'm not going to look at the confession, the alleged confession, and say, because number 1 has been implicated in that confession, and therefore I'll be now using a wrong test. If I were to refuse bail, I'm not saying so, but if I were to refuse bail for number 1 simply because he was implicated in the confession of number 1, that would be wrong. So that is why I'm asking you, except that he did not make a confession, what other what argument can you bring up to say we have a strong case against
There was one that was found inside his car.
that was found inside his car?
And according to the investigating officer, he assaulted the deceased. And also according to applicant number 3, he also assaulted the deceased. That's why
Number 3
she
said that under oath.
Indeed, Your Worship. That's what she said under oath.
And all that was said by the investigating officer about this commission of offense, she said she got it from the number.
Indeed, Your Worship. That's what she said.
Not in a confession.
No. Not in a confession. And also, he did the pointing out to show where the murder weapons were.
He led the police to
where
the
murder
scene.
weapons, indeed, Your Worship. To where the weapons were buried. Apparently, they were buried. And then that he led the police to where they were buried.
Are these the weapons that were taken,
They were taken
to the lab?
Indeed, Your Worship.
Okay. I see. But we are agreeable on this issue of the confession. Like it only binds the owner at this stage.
At this stage.
At this stage, yes. Because I'm aware later on, during trial, things may change. During trial, everything might change. What seems to be a watertight case during trial might just crumble into a weak case, or completely. It does, it happens, honestly. What seems to be a watertight case goes to the High Court and it comes and falls. But it's no one's fault. It's no one's fault. If that is all, it's fine. Thank you. Anything?
Thank you, Your Worship. Just some few aspects on reply. In respect of how the deceased moved from his home, my colleague said that it's so evident that she could not have been taken voluntarily.
Willing, yes.
Willingly. There is absolutely no evidence to that effect, except if she is giving evidence. Because even if subsequent.
Unless she's testifying from the bar.
Yes, yeah.
Put it like that.
Exactly.
Yeah.
Well, I mean,
Put it like
things
that.
would have turned. She would have went voluntarily, but maybe somewhere, then turned, and then they embarked on whatever fight, and then going to Grahamstown unwilling. But that wouldn't affect the issue of kidnapping. It would be just a crime of assaulting or killing. So that is the establishing that regard. And the thing about the weapons, my colleague said that these weapons were found during the pointing out. I think she's mistaken because she says that they were shown when they interviewed. Not, she doesn't know anything about the weapons. But my submission, I have submitted that evidence, insofar as it incriminates the accused. In fact, in respect of all the accused. Because she said that they never won. Such serious evidence. One would have expected to take a statement of this, you know. She said, no, I never won it. So I think the same argument I expressed, I submit. And then about the issue of suspension. The colleague said that she is suspended, but the issue is quite, I address it and she agreed with it. She knows this because it's not only known by myself, but there was this letter. It was returned to the Zolita department, but it did not come back. And the accused has not got any document that says it's suspended. He's still earning his salary from the Department of Education.
Is it?
Yes, exactly. From a facie case, the issue of prima facie case.
Do you have proof to that effect? That from
She's still
the day, yes, up until today,
yes.
he is still earning the salary.
It's good. Because I see nothing.
Yes.
Oh, quickly. Yes, what is a relative we can prove by taking out a bank statement on that date. It's the only proof we can have. Yeah. Bank statement. What we
All right, no, it's fine. Even if
Thank you.
it's okay.
Thank you.
I don't need that. For purpose of this bill, I don't think it's necessary for me to postpone this case in order for the bank statements to be brought.
No. I mean, I can submit that from the bar.
Yes.
Then, yeah.
Yeah.
So I think I am also satisfied with that.
Shh.
And then my colleague said that this evidence of Mr. Takara is a new thing. No, it's not a new thing, absolutely. Except as it was explained here that no, I should say that I've phoned the deputy principal. That is how I put it. But it's so.
It is the name, Jaka.
The name. It's the name that the deputy principal is Takara. That is as far as I can take it.
All right.
Briefly, Your Worship, with respect to...
You want the second bite of the chair?
Briefly, Your Worship.
All right.
Thank you, Your Worship. Your Worship, with respect to my then colleague's submission that Kungawo was taken forcibly from her home, I did put it to the investigating officer that, yes, there was a friend of Kungawo's at home. She was present when she saw the victim number one's crime, and him even, Your Worship. I put it to her, I asked her, did you ask this friend whether Kungawo was taken forcibly and the circumstances regarding her leaving home? She said no. If you really believe that there was a kidnapping, there is a prima facie case of kidnapping, that's the first point of reference that you must start at, Worship. From the witness who saw that, hey, there was a kidnapping here, how did it occur? But she never followed up on that. Then how can you satisfy ourselves that there was a kidnapping? Your Worship, as rightly alluded to by this honorable court, that the confessions made by accused number 2 and 3 may be challenged at the High Court. For us to say at this stage, for the state to say at this stage that this is what they're relying on to prove a strong case, it's not sufficient, Your Worship. They say that, the state is saying that there was blood found in applicant number 1's car, but however, Your Worship, I am making reference to the confessions in that at this stage there cannot be the sole piece of evidence that the state is relying on to prove a strong case, Your Worship. Your Worship, the investigating officer also said that applicant number 2 used a hosepipe piece that she found in applicant number 1's car to allegedly assault Kungawo. But this hosepipe piece was never found. She said applicant number 1 took her to where the other made weapons were buried. What about the hosepipe piece? Can we positively even now say, without DNA evidence, that applicant number 2 assaulted Kungawo? Can we go further and say she assaulted Kungawo using those weapons, Your Worship? No, we cannot say that at this stage, and we therefore submit, Your Worship, that the absence of a prima facie case against applicant number 2 is in itself, Your Worship, an exceptional circumstance that warrant for heavy use of the Worship.
All right, thank you, sir. May you now check on your diaries. Specifically, the 24th of October. Specifically, the 24th of October. The judgment may be noted, and it doesn't have to be here.
Yes. Yes.
24th of October, I'm suggesting that date for me to deliver the judgment.
That is fine.
Is it fine with
My
you?
colleagues,
Well, I'll just wait.
Your Worship, I think we are facing a bit of a predicament, Your Worship, regarding the 24th,
Yes.
because I will be on leave, and my colleague, Your Worship, was banking on the fact that I would note the judgment with him. He was not aware, Your Worship, that I would not be there.
The 24th is on Thursday.
Yes, Your Worship.
Will Mr. Matarai not be here?
No, Your Worship, he has written that he's on leave.
Mr. Matarai.
Yes, Your Worship.
So the 24th falls out. When are you returning back from your leave?
On the 28th, Your Worship, Monday the 23rd, but we have that excursion. So, even the date of the 29th, Your Worship, Mr. Matarana can move the judgment.
On the
29th, Your Worship.
29th.
Yes.
Say Mr. Matarai can note you will not be here.
Since it's a Tuesday, Your Worship, he can note on behalf of Mr. Matarana, Your Worship, as well.
Councillor,
29. Worship, I am satisfied with that date. But if there's a problem with that form for that and request to charge it.
so you are fine with the 29th?
Yes, 29.
You were also fine with the 24th?
Yes. I'm just, because I would have made sure that it happens. Maybe I phone someone to tell him to me if I'm not available.
Okay. I would have loved to postpone the matter to the 24th because we've been doing this bill for some time. I wanted to dispose of this matter. You know? Yeah. So I would have loved to deliver the judgment on the 24th. But now, if some of your colleagues will not be here, then what's the point? So we might as well go to the 29th.
29.
We might as well, even though to me it's far. Is it possible that I can get a copy of this whole bail application? Maybe next week.
Yes,
Can I get a copy of this? Subscribe, please. All right, please rise. Not you with the color. The litigants. All right. We have heard the arguments both from your respective defense counsel and also the state.
Sivile ke ingxoxo-mpikiswano ayisuka kumagqwetha enu ukubana ummangalelwa ngamnye negqwetha lakhe saphinda saliva necala lezothutshiso.
I must say that your attorneys are fighting that you must be released out on bail.
Mandiyithethe leyo ukubana ke abamangalelwa bethu amagqwetha enu ayalwela ukuba manithi nikhutshwe ngaphandle ngebheyili kwethu.
They have even referred to me to some decided cases, and I'm grateful for that.
Baye beke bathi bana makhe ndijonge ndinike ingqwalasela kumanye amatyala ke axotshelwa ngaphambili kwaye ndiyavuyela loo nto.
Even the state, on the other hand, is fighting tooth and nail that you must not be granted bail.
Kwaye nombuso kwenye icala ke nawo uyalwa awufuni tu ubana nifumane ibheyili.
State even referred me to a recently decided case of Nandi Goma versus the state.
Umbuso ke uke wathi mandiqwalasele ityala elitsha elisandugqitywa elika-Nandi Phamaphuthumane ejongene nombuso.
I am sure that even if you are not a lawyer, you must have heard something about Nandi Goma.
Ndiyaqiniseka nokubana ke angumntu uligqwetha kodwa ke inoba ukhe wava nguNandi Phamaphuthumane.
Now, if I've been addressed at length by the practitioners, and this has been a marathon bail application, it is not fair for me to deliver an extempore judgment.
Ukubana ke ndiye ndathi ke ndanikwa ingxelo okanye ingxoxo-mpikiswano ngamagqwetha enu ayicala lezothutshiso. Loo nto leyo ukubana ke ayilungelanga into yobana ndivele ndithathe isigqibo nje msinyane.
I will not be doing justice to this bail application if I were to do that.
Awube kanti andenzi kulungisa kwesi sicelo sebheyili ukubana ndingavele ndenze loo nto.
So my view is that this matter should be postponed for a judgment.
Umbono wam lo wokuba eli tyala malimiswe limiselwe isigqibo senkundla.
It is accordingly postponed to the 29th of October 2024 for judgment before this court at 9 o'clock. You will remain in custody until then.
Eli tyala liyamiselwa umhla we-29 ka-Okthobha unyaka 2024 limiselwa isigqibo senkundla lizawuthi liqale ngalaa mhla we-29 ka-Okthobha 2024 ngo-9 o'clock kusasa apha kule nkundla. Abamangalelwa bazawuhlala evalelwe de kube kanti ngulaa mhla we-29.
Then you may be seated.
Inkosi singahlala phantsi.
Okay. Yes, Mr.
Before we get adjourned, I want to postpone. Yes.
You still have cases to postpone?
Yes, Your Worship.
How many?
13.
What about the
There's
case
a-
that is stood down?
There's a fourth one. There's
You're going to postpone the three.
the three, yes, Your Worship.
Then you're going to be left with what has
With
proceeded.
the one that's proceed. I haven't consulted yet. Earlier on, I checked the comparable logic.
What is the time?
10 past 2.
That's true.
10 past 2.
Can't we have a 30 minutes adjournment? Council, you are excused, you are both excused.
Thank you, Your Worship.
Thank you.
I'm suggesting a 30 minutes adjournment. Unless then everyone is okay with that, we should proceed, then I don't have a problem. It's not good, school. So what do we do? Do we proceed? 10 minutes break. It's not done?
No, we can attend for 10 minutes, Your Worship.
You, Burgess?
Sarah,